May I have your lordship's leave?
Yes, Mr.
503 that arbitration matter. On the 14th of June, government has appointed an expert committee to look at the various issues. One of them would be this arbitral appointment process. Mr. Fali has joined me virtually and they moved an application before the UNCITRAL National Committee. The lordship think that the matter can be deferred for a while till the committee gives a report. Then we'll have the wisdom of what's happening. It is a consultative process.
That is serial number 502.
502.
Mr. Nariman has joined Mr. Nariman, the Attorney General was suggesting that we
and
over the hearing 502.
That would be preferable because, my lord, the reference by government is really for a new law to be enacted. That seems to be the memorandum of the government. So we don't know whether a new law will be enacted or not, so that the present reference about whether the bench of 3 judges on the one side is right or a bench of 3 judges on the other side is right, this idle. It will only take up much of your lordship's time.
What we can do is we can defer the hearing of 502. Who's on the other side for 502? So maybe we
and
can
504 both are together.
But what is the timeline? How long do you want us?
What I would suggest is, I think the committee should not take more than 2 months. And let me also try to expedite the proceedings of the committee. We'll give a report back to the committee, back to the court. As soon as the committee deliberations rear conclusion as far as particular issue is concerned, the manual lordship can take a decision on convening the court.
And the remit of the committee is to reconsider all the provisions of the Arbitration and Conciliation Act.
It's a very fairly large number of questions, but this question is incidentally also important.
It is not confined only to the issues.
No, there are other questions.
Other questions.
But I request the committee to focus on this question as early as possible.
And what is the date on which the committee was constituted by the government?
20th June. 14th of June. 14th of June.
Mr. R. Venkatramani.
This finds a reference in an application. There is an office memorandum dated 14th of June 2023.
Mr. R. Venkatramani, Learned Attorney General for India, submits that on 14 June 2023, the Union government has constituted an expert committee with a broad remit to consider the provisions of the Arbitration and Conciliation Act 1996. Full stop. The Attorney General states that, submits that in view of the issues which have been raised in the reference to the Constitution bench would undoubtedly would also come within the broad framework underlying the Constitution of the committee. Full stop. After the report of the committee, the government would take a considered view on the modification of the legislation is warranted.
What does 504 say?
Yes, we are saying 502 and 504.
Lordship.
504.
Mr. F.S. Nariman, Learned Senior Counsel, has also joined in making the same submission, as have the counsel appearing on behalf of the other parties. Stop. Hence, presently, we direct that the proceedings on the 2 references to the Constitution bench be deferred by a period of 2 months.
Your Lordship.
Full stop. The court shall be apprised on the next date of the progress which has been made following the constitution of the committee.
Fair enough.
So we'll list it, give a particular date. We are now in towards the middle of July, August, September. We can keep it sometime around the
End of September.
Can keep it on the 13th of September, which is a Wednesday, I think. 13th of September.
Yes, that's all right. Yes, certainly. Lordship, please.
Why is the committee to take into account the recommendation which you would give?
So there is needless.
The committee is bound to do that.
They're receiving
That's a different issue.
large number of.
That's a holistic consultation that will go on.
There's Mr. Banerjee says that. And this aspect can also be taken into account. And I hope you're also looking at the issue of the stamping of the arbitration agreement.
Yeah. What?
Stamping of the arbitration.
I see.
That will resolve the problem.
Not court's power.
Who's sitting on his left?
Roy. This is, here is Narasimha Rao, Narasimha, here is Roy. This is talking.
No, next.
Lordship.
One minute, just. Item 501 has a batch of 17 matters relating to appointments in the judicial service.
Yes.
I appear for respondent 501.4 on behalf of Manipur High Court, my lord. Though I am the respondent, my lord, but then the questions which arises for your lordship's consideration before the Constitution bench, I have formulated 6 questions circulated to your lordships and circulated to all my colleagues also, my lord. If your lordship so pleases, my lord, I can explain, my lord, because I have prepared a chart also of all the matters which are listed. They are coming from 6 different high courts. And Lord, what are the issues? I've just said one sentence in.
Now tell us, 1 second, now we just take a roll call of who's appearing in which matter. 501, who's appearing?
Lordship, I am appearing for 501 as the lead matter. And Lordship, I am not from the judiciary, I am the clerical staff of High Court. Lordship, I am different from others.
Go, let's go one after
One by one, yes.
501.
Lordship, I am there. I am for the petitioner. I am my matter 501 and 501.9.
Chetan.
Lordship, now in this matter, we in both the matters,
You're for the petitioner there?
Lordship.
I prepared a list
Oh.
of all these matters, Lord, if your lordship.
And Lordship,
Mr. Hansari, you've got a list of who's appearing in all matters? Just,
Not who's appearing, but what, which. high
okay,
court-
just give us that so we can write on that.
what it deals with, my lord.
All right, excellent.
For example, my lord.
Just 1 second.
Yes.
Let's at least, so that we have, there are 17 matters. Okay, so 501.
501
Lordship,
is.
factually,
there are
I am
four
different.
matters.
Different.
1 second, ma'am.
We'll call you.
501 is Tej Prakash Pathak versus Rajasthan High Court.
This relates to, my lord, appointment of translators.
Translators in the High Court. Okay.
501.8, there are four matters from Rajasthan. It relates to National Talent Search Examination, granting scholarship to class 10 students. 501.9, appointment of translators, and 501.10, appointment of translators. So 501, 501.9, and 501.10 are same, my lord.
Right.
501.8 is little different. Then second, Patna High Court, my lord, it relates to the same, my lord, 501.1 and 501.12, selection of district judge entry level in 2015-16.
Both same.
Then, my lord, there are three matters of Guwahati High Court, selection of district judge entry level in 2011. Like same selection, my lord, 501.2, 501.3, 501.11. Then, my lord, one matter from Manipur High Court in which I am appearing, 501.4. Selection of district entry level in 2015, where, my lord, there are judgments, my lord, where the difference of opinion between two honorable judges of this honorable court, detailed judgments. It was referred to, my lord, a larger bench, and then the three judges referred it to, my lord, a larger bench because of the pendency of this
So
matter.
it is in this that it arises, the reference order.
Reference is on the first matter, my lord.
This has no reference order.
Tej Prakash, Rajasthan.
Manipur has no reference order.
And 501.4, the two judges deferred. It went to three. Three said place it before 5.
Yes, my lord.
In view of the reference in
In
Tej
view of the
Prakash.
reference in the first matter.
All
There
right.
are two other issues which arise in the matter which I'll point out.
All
The
right.
petition amendments.
All right.
Then 5 is, my lord, Kerala High Court. Again, my lord, relates to district judges selection in 2017. 4 matters, my lord, same selection. And the 5th is from Gujarat High Court. Selection of post of district judge junior division in 2021 and 2022. 3 matters from there.
So except for 501.8, which deals with the National Council for Educational Research and Training, all other matters pertain to the high courts.
Please, your lordship.
I mean, high
Yes.
courts as the case may be the district judiciary.
Yes,
All right.
yes.
Now you've formulated now,
I
just
have
to
no
have us.
If I may
Now
intervene,
tell us,
with
just one
permission.
second, don't talk out of turn.
Just a minute.
Now tell us now, among the seniors who are appearing, just let's have an idea of who is appearing on this side and who is appearing on the other side. Who is appearing in support of the plea which the high courts are taking? We have Mr. Vijay Hansaria for the state of Manipur.
Manipur High Court.
Just one second, let's take that down.
High Court of Manipur, not state.
Sorry, yes.
Yes.
So we have Mr. Vijay Hansaria for the High Court of Manipur. Then who's appearing for the Rajasthan High Court? All right, Mr. Puneet Jain?
Sunil Kumar.
Sunil Kumar Jain. For the Rajasthan High Court. Right. Okay, that we got. Now, who's appearing for the Patna High Court? Mr. Gaurav Agarwal.
Issue, it doesn't arise, it's to matter. If I leave it to the petitioners to ask, is that there's an application actually to detach this matter.
Oh, I see.
1.1, because this issue doesn't arise, but I leave
Yes,
it.
but that's an issue pertaining to evaluation process. This is not concerning to the matters which are listed here.
So we can then detach the Patna High Court matter?
Yes, this issue of rule of change of rules of the game doesn't apply there, but subject to the petitioners arguing. They can still
Is there
argue.
any for the
Mr. Sharma is in fact appearing in
501.1.
Who's appearing for the petitioners in 501.12?
Lord, according to me, there are broad questions, Lord, that all the High Court assist your lordship, Lord, because the issues arise,
Fair
Lord,
enough.
that will have an impact on.
Mr. Agarwal, are you ready? You are ready with the point also, right?
I thought there's no material on the basis on which it has to be argued. I'm here.
No, on the principle, I
But this doesn't arise, so I don't know. I can address a lot of
To
general.
assist us.
to assist us, that's what I was. So we will say that we are we will delink 501.1. What we will do is, we'll retain 501.1 and 501.12 on the board.
Please do.
All right? Because we also want to ensure that our counsel who assist us can sort of mark a docket at the end of the hearing. So,
great pleasure to assist you.
So we'd like, all right. So, and then at the end, we will delink, go yaad rakhna, 501.1 and 501.12, we'll delink now. So
My
we've
lords,
got now the
also
question.
501.15, my
Just
lords, I
one second.
apologize to
Ma'am,
interrupt. I
ma'am,
apologize.
now, Guwahati, who's appearing for the High Court? Mr. Jose, right? Mr. Jose is, 201? Mr. Jose? Yes. Right. And then we are left with which High Court? Kerala.
Yes.
Kerala and Gujarat.
And Manipur.
My lords, for Gujarat High Court, I appear in 501.15. My lords, this is also a separate matter where the 2011 rules of the Gujarat Judicial Examination has been challenged. The rules of the game question is not an issue here, my lords.
Oh, 201 point?
501.15, my lords, which is Kirti Agarwal and others versus High Court of Gujarat.
Same in 501.16. Does this issue arise in one form? That arises.
My lords, in fact, in point 15, the same question with respect to the challenge of the rules is pending before another bench, my lords, in writ petition civil number 663 of 2021, my lords. So our matter may be tagged along with that and be heard along with that, my lords, because this question is similar to the question being decided therein.
What we will do is that we will just detag these matters. So 501.15, maybe we will detag them at the end.
Yes.
Because, after the arguments are heard, very briefly in 2 minutes, we look at all the matters and then decide what is to be detagged. Because for all we know that, something might, incidentally arise here. So,
Overlap quite a few.
May I come in for Manipur for half a minute?
just one second. So for Gujarat, we have Shraddha Deshmukh. Anybody else for the Gujarat High Court in these three matters? Shraddha, you are appearing for all the three matters?
My lords, I'm appearing for the petitioners in this case, not for the
Not
Gujarat
for the
High
High
Court.
Court. Petitioners,
Not
we
for the
just,
High
anybody who's for the Gujarat High Court? Panvita normally appears. All right. In Rajasthan, we have Sunil Kumar Jain and Pawan Shwetawal. So we have now the list of people who are arguing for the High Court.
Manipur, I need to clarify something. Manoj.
Yes.
Manipur, Manoj, there is a difference of opinion.
Guwahati is
Page
Jose.
501.4.
Yes.
Whereas Manipur High Court, the slight difference in this matter is Tej Prakash would be stage 2 if stage 1 is crossed, because the judges differed on all 3 points which were raised in the matter. This is Bhanumati as she then was held against us, against the petitioner. Justice Shivkirti Singh as he then was held in our favor in all 3 points. They differed on all 3 points. So stage 1 was whether they, by executive instructions, 309 rules could be overridden. That's the stage 1. If they cross that, then Tej Prakash would come. The rules of the game is the second stage at that, and then procedural unfairness. On all 3 issues were raised before the court.
Therefore, we will have to decide the constitution. We'll keep this matter with us.
Yes, Madam.
Because our decision on stage 2,
Yes.
you're right, it may not arise until stage 1 is crossed.
That's right,
But we'd like to have the assistance on
Very
stage
well, I'll
2.
be here. I'll be here on
And
that.
eventually we'll send it to the 2-judge bench to hear the
3 judges because of the
3
difference of
judges.
opinion.
Yes, the 3-judge bench.
I just wanted to place it on record so that
Right.
it's not that we have to only argue Tej Prakash. We have
So that is a serial number.
that is 501.4 minutes. That's the one you
Go
put.
to the 3 judges.
Manipur.
Larger issue is of the full court reference recommendation, which did
Right.
not amend the rules. I'll argue that also, if you watch it to
All right.
so.
And Mr. Natraj, who are you appearing for?
Although in the matters direct flow in the particular issue, but the larger issue.
We'll require your assistance on that. So you please be there so that, because this also affect you in other service matters. It just so happens that these are broadly only High Court matters except for one.
Apart from this was not it was challenged by the included in the final deciding the color. It was granted by Rastan Hekuri and the executive of King
That nothing apart from the English marks could be considered.
Is that the English mark earlier was, but first time the committee has decided making the English qualifying mark, considering overall impact of all of it. Are not.
All right, that's our individual facts. We really need to address on the. Anyway, we're not looking at individual cases. We'll see the case. So now, what we can.
No.
All right. All right. So what we'll do now is this. The lawyers who are appearing for the private parties in all these matters, please give us your appearances on a slip of paper. We just wanted to know, broadly, who's appearing for the High Court so that we have everybody present here to at least start the arguments. So now, we can hear Mr. Vijay Hansaria for the High Court.
Yes,
Mr. Nataraj, would you like to go first, or Mr. Hansaria will argue first so that you have some, because you don't have a live matter.
Our role may come only later.
All right. So we can hear Mr. Hansaria. Then we can hear Mr. Who would like to go after that? Mr. Sunil Kumar Jain. Then we have Gaurav Agarwal, Jose, Sheshadri Naidu, and Deepanvita. So 5 councillors.
I would like to hear the petitioners first because
we can do that, no difficulty.
Because that's because they'll have to respond to the changes that they are supposed to have made in each High Court.
So what we can do is we can only request Mr. Hansaria, who has formulated the questions, to show us what his formulation is. We can share it with all of you. If somebody wants some little change, we can. Someone here on this side. Who all will appear? And for the petitioners, Haripriya, will you just take it upon yourself to tell us, Mr. Chidambaresh? Mr. Chidambaresh will be appearing for the petitioners in the Kerala matter. All right. Who are going to be appearing for the petitioners and how long would you take? So we'll start then with the petitioners because technically, you have to start first.
I've seen the questions, my lord.
No, whoever is wanting to appear on this.
Who's for the petitioners now? Tell us.
Give us the details so that you will collate and then tell us.
Now for the petitioners, who will open the arguments?
Kerala matter, I may open that. Because my item is 05 and 06, 501. Petition.
You are in 06 for the petitioners.
Because 5 and 6, there are batch of matter. 5 and 6.
So Kerala for the petitioners, Dinesh, Haripriya and Ragen Basant are going to be appearing. Mr. Chidambaresh also. All right, no problem. We'll hear you. Now, in the other cases, for Rajasthan, Patna, Guwahati and Gujarat, who are for the petitioners?
I am for the Patna. Petitioner in Patna High Court matter.
So on the side of the petitioners, please give your not appearances, but just a small note to Ms. Haripriya Padmanabhan, so she can prepare it in a consolidated way and give it to us so that we can call out matters seriatim then.
I would
statewise. Right.
We'll finish Kerala, then go to.
So on behalf of the state, on behalf of the petitioners, we'll go statewise. All right. So we can perhaps do Kerala first, I think Kerala will be the, yeah, because you have Siddhambaram, you have Dinesh, you have
I would rather have Manipur at the end, my lords, because
All right.
that's some additional point.
No problem, Mr.
Independent of those
Mukherjee.
6 questions, which are
Absolutely.
formulated and given to you.
So
All
we'll
right.
do Kerala first.
We'll do Kerala.
So either in the beginning or in the end, because I am the clerical staff and I am different from others.
All right.
Tej Prakash here.
We'll take up each set. So what we will do now is, so first we will take up Kerala.
Lord, I have formulated the question.
Just once again. So the order will be, we will first take up Kerala, then we will take up Rajasthan, then we can take up.
Subject to your lordship's pleasure. What I was submitting is, my lord, the submissions.
Just one second.
Broadly, we'll.
We are just telling, we'll take up Kerala, Rajasthan, Patna, Guwahati. Then we can say tentatively Guwahati,
Manipur and
Gujarat and Manipur. Yes.
What?
Yes.
You can't be converting Assam, it's Guwahati High Court, it's not Assam High Court.
Yeah, it is Guwahati High Court.
May I point out one thing?
Mrs. Naidu will be available only in the afternoon, you know, for appearing.
petitioners are going to
Petitioners are
start. So therefore,
starting,
there
and
won't be
Mr. Naidu is for the High Court, so he can come.
May I point out one thing?
Yes.
All this batch of matters,
Kerala, Rajasthan, Patna, Guwahati, Gujarat and Manipur.
in all these batch of matters, the situations are different from each high courts where they have interpreted.
Right.
So ultimately, the reference is also, I mean, bit vague, unless what exactly is the reference and how it is
You must
applicable.
read the reference order.
Yeah.
Yes.
We'll read the reference
Yes.
order by Justice Chalmeshwar's,
That will be possible.
yes.
Necessary. And the fact situations each.
Then we will have to see a little bit of the fact situation for
Yeah.
all the states
Yeah.
actually, because you know, we can't just decide it in the abstract. All right. Yeah. Some of the broad. Yeah, now, should we have a look at what you have prepared?
Yes,
so
Lord.
that we can get started.
And kindly filed a police written submissions on behalf of Manipur High Court. Writ petition 294 of repeating. Yes.
Let's see what is formulated. तारीख है 12 में. Next, 12.
Yours is a 6-page folder?
Yes, 6-page note, my lord, yes. There is compilation of, my lord, the case laws which has been shared with all my colleagues also.
Just one. Six-page note, yes.
My lord, sir. The following questions arise for consideration of this honorable court in the present set of matters. One, whether the selection of judges of the district judiciary and staff, I'm including staff because one of the matters related to translators. Cut-off marks and the fixed for both written examination for Viva Voce examination and a candidate to be included in the select list must secure the minimum qualifying marks for both written and Viva. Because, my lord, one of the argument of the petitioner side is, my lord, the City Commission said there should be no minimum for Viva, which, as per the argument, all India Judges List is accepted. We have a submission to make. That's one issue which arises. Whether the cutoff marks must mandatorily be fixed in the service rules or can be fixed by the executive order issued by the High Court. whether in changing the cutoff mark after the selection process is started amounts to changing the rules of the game and is impermissible in law. Whether the selection is based, where the selection is based both on written and viva, what should be the proportion of marks to the main written examination and viva course, and what should be the percentage of cutoff marks for the written examination for the viva course. Whether the marks.
All these issues, do they arise in before the constitution bench?
They will not.
Yes.
You may have
That's
collated it.
Manipur is separate, but that's what I was
That's
trying to
right.
impress.
Mr. Hansaria, you may have
It's a slightly
collated all,
separate
you
matters.
may have formulated it
Yes,
on the basis of issues arising in
The
this
case.
batch of matters
yes, my lord.
put together, but then the reference is on the basis of the judgment of Chalameshwar.
Yes,
He
my
refers.
Essentially,
only
the question, my lord, whether the rules of the game
These
can be
matters,
changed
for
after
example,
the rules
Manipur
play.
matter is also.
That is the reference.
Placed before the constitution bench.
We will see the, so therefore Manipur also will see.
Manipur,
where the
that's why I
three
reserve my right
have
to
referred.
respond to this. These questions do not directly arise in Manipur. Tej Prakash is instantly there. So I'll have to make good. That's why I want to come in at the end.
So ideally,
I
I
want to
think
come
what we
in-
must do is, we must look at the reference order.
Yes, absolutely.
And having looked at the reference order, then we will look at the individual state facts. You see, we'll take up each individual state, and we are going to go, as I said, first.
Two more questions, my lord. Can I
To the
complete
Kerala
it?
High Court.
Then take your lordship to the reference order.
Yes.
Just two more questions, my lord,
Yes.
on the next page, page 2. Whether
Because
the-
we shouldn't be answering questions which really arise before a 2 or 3 judge bench, in that case.
That would be actually proper.
Yeah.
Broaden the scope of the reference also.
Then we will-
That's right. But can I come? My submission in Manipur is Tej Prakash is not directly attracted to it. It comes as stage 2. So therefore, you have to cross the first threshold. And that is not before your lordships.
All right, what,
Let us read the reference question
Yes.
first,
I will just
so
show
that we
all the-
confine ourselves to what is to be answered.
Yes, my lord. I
Because
will-
there could be peripheral issues in any of the cases.
Yes, that's, just two more questions and then I'll go straight away go to the Tej Prakash, my lord, reference. order.
yesterday, man. You wanted to read the last two questions, right?
Yes, my lord. And then I'll take your lordship to the reference order, my lord. Whether the marks of the written examination should be published and or made available to the members of the interview board before awarding the marks in the viva. But two of your judgments says, my lord, that it should not be made available. There are two judgments of your lordship's court. Whether a candidate has an indefeasible right to be appointed if she has been considered for viva and or her name is included in the select list, and whether the High Court as an employer is bound to fill all the vacancies notified in the arbitration.
All right, now we've got your point. Now, just one second, Mr. Hansaria.
Yes.
Now, what we'll do is, we will take up Kerala first.
Very
Can we go straight now to Kerala for a moment? Who's going to open arguments for Kerala?
I'll
Dinesh, you are opening arguments for Kerala.
Yes, my lord.
So we'll start with now.
Reference order in Kerala.
Yeah, let's go to the reference order for a second. In the
Lakshmi, kindly.
Mr. Dinesh, you are appearing. You'll be appearing in.
In 50105 and 06, my lords. But 05 and 06 are batch of matters. So in 06, other my learned friends are also appearing in 06.
So 501.5 and 6, right?
Yes, my lords. That is the lead case in Kerala matter, Shivanand.
The reference order is in 501.5 also in the paper book there.
Yes,
Or do otherwise we have it in 501? We can read it anywhere.
Compilation of judgments and soft copies available with my lords, filed by Mr. Ansari, my lords. I can refer to that, the soft copy. So everybody can refer to that soft copy, my lords.
You have filed the convenience compilation.
Yes, madam. We have filed four volumes, my lord. So Ansari has five files, my lord.
So now,
Party matter, I filed first three by mistake.
and we have got the convenience compilation.
There are four volumes of 1, 2, 3.
In fact,
Dinesh, where is the reference order in your convenience compilation?
Kindly see convenient compilation part 2. In fact, there are 3 convenient compilations Mr. Ansari has filed, and part 1, part 2, and part 3. I am referring to part 2, serial number 13.
Convenience compilation 2.
Yes.
213.
Yes. Serial number 13, Shivanandan CT versus State of Kerala.
Short order, my lords.
The Honorable Mr. Justice Kurian Joseph and Honorable Mr. Justice Panwal.
PDF 260. Sivanandan, na?
Yes, ma'am. The convenient compilation 525 is the serial number. 2018 1 SEC 213.
मिला आपको? Yes, just state it, yeah. अंग्रेज में मिला आपको? अच्छा, you just get it for you. You know, in Hansaria's compilation, if you click on Hansaria, you'll get his convenience compilation 1, 2, 3. Huh? Hansaria's compilation. Yes, so that I got. Wait, in Hansaria's compilation, yes. Just click on Hansaria. Then there's convenience compilation 1, 2.
It's a running page of compilation is 526.
Is referring to compilation using PDF.
PDF.
Numbers, it's better.
This PDF compilation, my lord.
Just
526.
go by PDF. Tell us PDF number.
T526.
Which para you want?
Please, my lord.
Para?
So, lords, this is a reference order, my lords. I have already submit, my lords. In fact,
Wait, yes. आप मित्तल सबको भी देते खुल गया है लेकिन compilation. Yeah, sir, just go back. There are answers to our same compilation. Compilation 2 is opening. That's About it 259. 259. That is Sivanandan CT versus High Court of Kerala.
Before reading this, my lords, may I make oral submission so that it will be easy, my lords. I'll just 3 minutes. I'll just tell you the facts, my lords, which led to this. Not the basic facts only for the necessary information. My lords, this is in respect of appointment to the post of district and sessions judge in Kerala.
Yes.
And we have a rule which covers the selection process, which is called Kerala State Higher Judicial Service Special Rules 1961.
Yes.
The selection process normally in Kerala, this is in respect of selection of 2015. We are concerned with selection of notification of 2015.
Yes.
prior to 2015, all those selection process were as per the rules, took place as per the rules. And rule says that the selection will be, because there is a written examination and viva voce. Written examination, there are 2 papers, 150 marks each, and viva voce 50 marks, total 350 marks. Written examination, you have to score general candidates 50%, and exemptions are there for the reserved categories, like 40%. Then only you will be considered for the interview. And the selection will be as per the rule 2C Roman 3, my lords. The criteria for selection is the aggregate of written examination and viva voce will be taken together, and that marks will be the selection for the purpose of select list. That is the final. And selection happened in the year 2014, same way. And 4 of my clients here, the petitioners in the first matter, there was no cutoff marks so far as interview was concerned as per the rule. 2014, the petitioners, 4 of the petitioners participated. They scored more than 50% in the interview, but aggregate they lost. So the selection committee said, sorry, you don't have aggregate marks. Though you have 50%, they were out. They were not selected. 2015, this selection, 2015 was the notification. Examination was conducted in the month of March 2016. February 2016, my lords. 17 it happened. Then I'm sorry, I'll correct my dates. The selection process, the examination was conducted in 2016. Thereafter, the results were declared in December 2016. Out of 400 candidates, 40 candidates scored more than 50%, qualified for the interview. So 40 candidates were declared and they were part of the select list, scoring more than 50% in the written examination. They were called for interview in the next year. An interview took place on 16/1/2017 to 24/1/2017. Yes, 17. Thereafter, my lords, after 8 days, administrative committee met. This is how the issue comes, my lords, here. Administrative committee met on 6th of February 2017. Then administrative committee took a decision that in the interview, the person should score more than 50% marks. That is, they fixed a cutoff mark after the interview took place, after the written examination, as well as the interview. The administrative committee met after a few days of the interview, because then took a decision saying that those candidates who have not scored more than 50% of the interview, so interview became the sole criteria. And thereafter, on 21st of March 2017, the full court met and gave approval to the administrative committee's decision. The selection committee was consisting of 5 senior-most judges of the Honorable High Court. And selection committee and administrative committee, the members are one and the same. They conducted the interview.
So your contention basically is that once the process had begun,
yes,
what they did was that after the interviews were held, they decided to have a cutoff of 50% marks in the interview, which according to you is impermissible.
Then, my lords, what happened? That is the cliche has been used that rules can be, you can change the rules after the game is played. But in fact, my case would be
after the interview. This is actually after the interview.
This is after the interview. After the interview. And I'll just come to the other aspects, my lords. So my case may not be, the reference itself may not be recurred for the simple reason that it's a straightaway violation of an existing rule. So whether...
What does the rule say, you say?
Rule, my lords, 2C3
and
of Kerala State Higher Judicial Services Special Rules 1961.
2C small 3.
Yes, my lords.
So rule 2C, what? Small 3.
Yes.
What are the rules called?
My lords, Kerala State Higher Judicial Services Special Rules 1961. My lords, this is a rule under Article 233 read with 309, my lords.
Special rules.
Yes, my lord, special rules.
1960.
Because there is a separate special rule framed under Article 234, but this is a rule framed under Article 233 for the higher judiciary, subordinate judiciary.
Rule contemplated taking only the aggregate marks into account.
Rule contemplates very specifically, and that was the practice also followed by the High Court, that the aggregate of written examination and the viva voce should be taken together, and that is the test result.
Your submission is straightforward, saying that the
my
administrative decision,
yes, madam,
as well as the selection committee's decision as approved by the full court is contrary to the rule.
Contrary to the rules.
So really speaking, the issue of the change in the rules of the game, etc., doesn't arise because
arise at all,
the rule itself says that you have to take the aggregate.
So my response,
you can't do by an administrative notification what is contrary to the rules.
And all the judgments so far, supported by Honorable High Court and this side, it very specifically says that the Lordship have held that even 142 Your Lordship may not go against the specific rules, my lords. And we see Mr. and all those cases, my lords.
So Dinesh, was any attempt made to amend the rules thereafter?
In 2017, later on. Later on, they fixed 35%. Rule was amended.
For the interview.
For the subsequent elections, for the interview.
And for this particular selection of 2015, the operative rule did not provide us a minimum cutoff in the interview.
Very specifically.
On the contrary, it says that the selection would be made on the basis of the aggregate marks which are obtained in both.
Exactly.
Now, tell us about the litigation. What happened?
Litigation, then we straight away approached this Honorable Court in 2017.
32 petition.
Yes, 32 petition, my lords, because there is a contrary. Because what really prompted us to approach this Honorable Court directly is that all those challenges were pending in the High Court and happens after 5 years or 6 years. So instead, there is a direct contradiction to the rules, my lord. Straight away we came.
So you filed a writ petition before the Kerala High Court.
Came to this Honorable Court, in this Honorable Court.
32 petition.
32 petition.
Then?
32 petition, notice was issued and the arguments took place. And finally, there was, there is a reference order, the Tej Prakash was cited, saying that there is a change of rules after the game is played. In that case, it's as per the Tej Prakash reference order, this should be referred to along with the Tej Prakash case.
So you cited Tej Prakash?
No, my lords, I cited Tej Prakash.
All right.
Then we objected to it, and Tej Prakash is a case where there is no cutoff date at all for the interview. Cutoff marks at all.
Now tell us one thing, just to argue on the other side,
yes,
just sort of to elicit your response. The rule says that the selection will be made on the basis of the aggregate marks in the written and the viva voce. The rule is silent about whether you must also obtain minimum marks in the interview.
Yes.
The rule, according to you, it tacitly also it tacitly excludes the possibility of fixing minimum marks in the interview.
Expressly.
Could it not be argued that look, the rule is silent on what the minimum marks in the interview
in that case, I would like to refer to the rule framed under Article 234, which talks about suitable person can be selected. So there is a question of suitability in 234 rules for the municipal magistrate selections matters. That suitability enables the High Court to fix some criteria. Here it is blank. So there is when you compare 233 rules and 234 rules matters, there is an express difference. There is a clarity there, and there is no power given to High Court under 233, even under the rules, my lords. There is a specific rule. That is a specific.
The question to you is that the rule does not itself prohibit it.
Please, my lords.
So therefore, there must be perhaps you could interpret it to say that there is some amount of freedom for the High Court to modulate it and then ensure that somebody best can be picked up.
For the purpose of interpretation.
Because the fixation of the minimum marks in the interview.
For getting the correct candidates, better
candidates. For getting better. Is still consistent with the rule which says that the ultimate selection will be made on the basis of your aggregate marks in both.
Aggregate marks.
The only problem with this construction which I am suggesting is that it will lead to an exclusion. It will lead to exclusion of those candidates who would have made it on the basis of the aggregate marks only on the ground that they have not received the minimum marks in the viva.
That is precisely my
There will be a clear conflict with the rule.
That is precisely my submission, my lords. 2014.
Because there will be several candidates, possibly, who would have gotten on the basis of the aggregate marks They may have got low marks in the interview, but that is more than offset by the high marks in the written. And they would be in that merit list, but they would be excluded because they get, say, less than 35% marks in the interview.
This in fact happened, 2014.
It
Four of us, no other candidates, no other case. 2014, we 4 people appeared, scored more than 50% in the interview. But aggregate, I was not having, these 4 people were not having more aggregate. And when you compare the aggregate marks, they were down the list.
So if they had applied this yardstick in the 2014 selection, probably you would have made it then. In 2014. But they don't apply the yardstick which they applied in 2014.
High Court followed the rules
In 2014.
Then 2017, High Court amended the rules also. And here 2017.
Now tell us one more thing.
Please, my lords.
What has happened in the meantime? People have been appointed.
My lords, there is an interim order by this Honorable Court where my lord is also party to, which says that it will be subject to selection, my lords. But those people got into service and they have been cut.
Dinesh, 6 years down the line.
Yes, my lords.
You have lost out on seniority for 6 years. Those people have already come in 6 years.
That is a fact, my lords. That's a fact, my lords, but.
It's so important to deal with early. This place, people are working.
There is
do this.
Yes,
we will go to your paper book. Look at the list of dates. You have given us the idea.
Please, my lords.
What we will do is we'll see if the reference arises at all in your matter.
Please, my lords.
All right? And we'll see what to do. Come now, show it.
One more thing, the remaining matters which are there under the Kerala list that he has given, all of them arise same issue.
Same selection.
There is no other Kerala issue.
No other Kerala issue.
Then okay.
Lords, one more.
Because Kerala is the selection of 2017.
My lords, before I finish, my lords, one more respectful submission, my lords. In fact, Kerala High Court filed a written.
1 second.
Counter.
Sabhi conception. Kerala का ये 2017.
My lords. Lords,
Reference order of Justice Kurian Joseph and Justice Bhanumati, and then we'll go to your paper book.
please, my lords. Lords, may I kindly see the same page, my lords?
Small order, so it will
Page
take us
25.
3-4 minutes. Yes.
Lords, may I
You also
kindly-
give us the facts right away over here.
Yes, my lords.
IPM? All right. All right. Yes, Dinesh?
May I read that, my lords? Reference order.
Yes.
Lords, para 3, may I read para 3? Para 3, my lords. As a matter of fact, 2 selections were.
Just read from para 1 actually, you might as well now.
Para 1 minute.
One, yeah.
Please, madam. The selection of district and sessions judges in Kerala Judicial Service in the year 2015 has given rise to this litigation. As per the notification dated 30/9/2015, the selection was to be conducted by written examination and viva voce. Written examination of 2 papers carried 300 marks, 150 marks each for the paper. Viva voce was for 50 marks. It was stipulated that those OBC candidates who secured 50% marks in written examination without any separate minimum and SC/ST who secured 40% were qualified to participate in the viva voce. In terms of the resolution of the full court, 13/2/2012, there should be no minimum cutoff marks for interview. The final merit list was to be prepared in the following manner. The merit list of successful candidates will be prepared on the basis of the total marks obtained in the written examination and viva voce. As para 3. As a matter of fact, 2 selections were held in the year 2013 and 14 without cutoff marks for viva voce. As for the resolution dated 13/12/2012, and after publishing the result of examination, the candidates were interviewed by the selection committee. However, after the viva voce, the administrative committee, consisting of the same members as the selection committee, resolved to draw up a list of successful candidates on the basis of the same separate minimum percentage of marks in the viva voce as in the written examination. According to the administrative committee, the fixing of minimum marks for viva voce was not a deviation from the approved scheme, since it was never the intention of the full court to select persons who do not attain the minimum required benchmark for such responsible post. The merit list thus drawn by the administrative committee on the basis of the minimum marks in the viva voce was approved by the full court, and those candidates were appointed accordingly. That selection is challenged in these cases. The main contention is that rules of the game could not have been changed after the game is played and the result of the game is known to the selectors. Though the several other contentions are raised by both sides, we find that the decision in K. Manjushree versus State of AP squarely applies to the facts of this case. In Manjushree, 75 marks were allotted for written examination and 25 marks for interview. Aggregate governed the merit. However, the written examination was conducted for 100 marks. When the full court noticed this, a subcommittee was appointed to make arithmetical correction to scale down the marks in the written examination to 75 instead of 100. The subcommittee did 2 things. It made the arithmetical correction. Second, it introduced same cutoff percentage for the interview as in the written examination and thus revised the merit list, which was approved by the full court. In the process, a few candidates were removed from the original merit list, including Manjushree. The bench of 3 judges of this court held that introduction of the requirement of minimum cutoff marks for interview after the entire selection process, consisting of written examination and interview, was completed would amount to changing the rules of the game after game was played, which is clearly impermissible. The bench specifically noted that resolution of the full court to not specifically stipulate minimum marks for viva voce was still in force. Yet, when the subcommittee introduced the change, the same was approved by full court. In Tej Prakash Pathak versus Rajasthan High Court has, however, specifically doubted the correctness of Manjushree on the point whether changing the rules of the game after the game was played is clearly impermissible, as made a reference to larger bench for authoritative pronouncement. It is also relevant in this context to note that Salam Samarjit Singh versus High Court of Manipur, which dealt with almost a similar issue, was heard by 3-judge bench in view of the difference of opinion, and it has also been posted along with Tej Prakash by order dated 10/8/2017. Hence, it is only appropriate to refer this matter also to the larger bench to be heard along with the Tej Prakash.
Now, the reference order does not notice a rule. It doesn't refer to Rule 2C3, which you have referred to in your submissions.
Did you appear, Dinesh? Did you not find out this point?
Argued, Malik. The rule was the main contention.
Right.
Now, they refer to the aggregate. That is the rule.
That is the rule. In fact, they rely upon a
full court
scheme of 2012. There was no cutoff date. My lords, the High Court counter, you'll also get correct picture when you go through the counter of the High Court, my lords. Very interesting counter. High Court, so far as interview mark is concerned, the contention of the High Court is that it's a fluctuating affair. On some date, the interview marks will be high. On some other date, interview, such a casual manner it has been prepared, my lord. Some date, interview marks will be less. And Shetty Commission report is there. There can't be any cutoff date which has been accepted by this Honorable Court for the purpose of selection, my lords. That is also argued, and High Court said there are certain other recommendations of Shetty Commission which was not accepted. So it is not correct to say that you have to accept Shetty Commission in toto. So we can take a decision. Then High Court also acknowledges that there is a rule. But for the purpose of getting better candidates, we are taking this measure. And High Court also, there is 5 categories for the purpose of interview. They have made 5 categories, normally for the grading, for the purpose. And the merits and judging, they said this is the most important affair. So for us, other cases like integrity, honesty, etc., that is the least important affair. So that we have given marks. So far as those people are concerned, judgment, we are not given those marks. But in fact, the written examination is nothing but assessing of skills of judgment.
Now, tell us only one more thing. Can we now look at the rules first? I think let's look at the rules which govern, because that's the most crucial thing.
My paper book, Melos, it contains everything.
Yes.
Otherwise, there is a compilers.
1 second, we'll get it here.
We have your paper.
We've got your paper book. So you are appearing Dinesh in 501.5
Yes, Melos.
You want us to take convenience or your written?
Convenience compilation, my lords.
of Mr. Hansaria?
No, Dinesh.
No, my lords, I have filed a convenience compilation, my lords. In fact, convenience compilation, I have filed separately, my lords.
Yeah. You've got your convenience compilation.
Yes, my lords.
मिला आपको 1.12 नहीं इनका there is a separate convenience compilation.
That is at running 823, PDF 823, my lords. In the Shivananda's paper book.
It's in 501.5.
In the paper book, which is circulated to all of us, my lord, the registry is given us. So in the 501.5, the rules are there at page 834.
There is 823.
Oh, right.
First, may kindly see Shivananda's compilation circulated by the registry, my lords.
All right.
There the 823 index, it starts from index. That's PDF 826, in fact, starts. Where the rules starts from rules.
Which page you want?
826. In fact, the index is at index begins at page 823. Shivanandan's compilation.
Your convenience compilation is 139 pages.
Shivanandan, there is a separate convenient compilation which I filed in the Shivanandan's paper book, which running into more than 800 pages, my lords.
This is the compilation.
Because there is a separate paper book.
Okay,
soft copy of the paper
I have the paper book separately. I'll take the compilation.
Well, Lordship, see page 834, PDF page 834, but you would get that.
You put it in the paper book, is it?
Convenience compilation, no?
Yes, convenience compilation, which I filed about
And
20 documents, my lords, 23.
right. And which document are you referring to?
I start from the first, my lords, that you also can see the rules. Document number 1, my lords.
And that's the page I was saying, 834 PDF, Lordship, get that's the same.
I have the convenience compilation.
Yes.
Page 2 of that.
The heading is convenient compilation note at page 838.
You want to refer to the rules, right?
Please, my lord, I'll just take
That is the rules of 11th of July, 1961.
1961.
And it refers at the top, there's a handwritten endorsement, document number 1.
Document number 1, my lord.
Got it?
Correct, my lord.
You got it. मिला Ravi? अपना हीरा ऋषि मिला इनको मेरे को अच्छा मिला ऊपर document number 1 है हाँ that's good now only Pankaj bhai
हो गया. Submission by Dinesh. We are seeing that.
Yes.
First document number 1, my lords.
Just 1 second, my learned brother, just Mittal case here. इसको final है. Problem. Saying look at the condition what we have given. points would then go there. You could have running volumes for everybody. I read that. Okay.
Yes, if you can.
Yeah. Yes.
Please, my lords.
Rule.
My lords, your lordship may kindly see the rule in exercise of powers under 233 and provides to Article 309. The rule framed under, my lords.
Yes.
Just below the notification. Now, my lords, the rules, there are 3 modes of selection, my lords. We are concerned with category number 3. Entry level, my lords. And the category number 3, 25%, my lords. 25% is earmark, which your lordship may kindly see 828 or internal page 3, my lords.
No, it just, let's go to 2C, method of appointment.
Yes, my lords. 2C, my lords.
Appointment to categories 3 shall be made as follows.
Yes, my lords. 50% of the posts in the category shall be filled up by the appointment by transfer from category number 1. And may I read further, my lords?
Yes.
25% of the category shall be filled up by the appointment by transfer based on limited competitive examination and viva voce and on the basis of merit and ability from category number.
We are not concerned with that.
We are not concerned with that. And your lordship may kindly come to
3.
25% of posts in the category shall be filled up by direct recruitment from the bar on the basis of aggregate marks grade obtained in a competitive examination and viva voce conducted by the High Court. This is the rule.
What this rule seems to suggest is that you have to aggregate, you have to accumulate both together and then
That's the final.
that's the final.
Please, my lords.
You see, there could also be a situation of, we have the rules here, and in the Kerala case, of course, there was no departure from the rules. But then suppose on an overall look at things, even if you come in the select list on the basis of the aggregate, you don't have an indivisible right of appointment, right? That is understood. So in that case, suppose they fix a cutoff in order to get the best people in the perception of the selecting authority.
Sure.
Can you say that that should not be permitted?
But it should not be prejudicial to my rights, or there should be interstate discrimination among the persons who are appearing for the examination.
In what way you are saying there is interstate discrimination?
Lords, fixing a cutoff date, like Tej Prakash.
You mean to say that somebody who has scored lower in the written marks,
True, my lords.
and you have scored higher, you will sort of lose out because the other person has got the above the cutoff in the viva.
Viva. Because Viva, why the Shetty Commission said, Viva, we can't mistrust, we can't question 5 honorable judges, my lords, and their wisdom. But there are inherent problems with Viva was. There are a lot of tests also. I can take my lords to the test on bias, my lords. And I saw certain literature.
But here we proceed on the basis that the viva is a valid method, and because the marks for the viva are only 25, right?
25.
So we proceed
50%. 50% of the total marks of viva. In
But
2017,
there's no challenge to the marks allocated for the viva over here.
50 marks.
How much?
50 marks and 25 is the cutoff. So you have to secure 50%.
Actually, you can phrase your argument in this way. Suppose you prepare 2 lists. One list consisting of the aggregate marks which you have obtained in the viva and the written examination. Together, cumulative. Aggregate them and prepare a list which will give you an order of merit. Second list, for comparison, prepare a list of persons who get at least minimum cutoff marks in the interview, plus the marks which are obtained in the written examination, and prepare a merit list. Many people who are in the first list may not be in the second list, because though they were high enough in the order of merit to warrant selection in the first list. By virtue of the fact that they didn't get 50% marks in the interview, they would be out of the second list.
But there can be a situation, my
Are
lord.
there such people before us
No,
who
there
got
are.
excluded?
Let me kindly say,
Okay.
there is a case
They are
where
there, it's all
a
right.
person can, in interview, 25 marks he should score. The person is getting only 24. And he has got high on the merit list, written examination. He's also out. So here a situation where interview becomes the sole criteria to judge. And we have to see how the High Court dealt with the situation. Suppose,
Now tell us, where did we get this thing about how many marks for the written exam, how many marks for the interview?
my lords, there it is in the advertisement notification. Notification was in.
Where is that notification?
I
over
just
here?
come to the notification, my lords.
No,
I'll
in
produce
this
the-
compilation,
this
Dinesh,
compilation,
In the compilation itself, it is there, my lords. Your lords, may kindly see the notification.
22, page 20.
D4, document number 4, my lords. And
let's go to that.
no, D6, my lords. The D4 is 2014 notification.
Yeah, 37.
And 863, document number 6.
That is PDF page 871.
39, 2015 notification?
This is, my lords, 39, 2015 notification.
Page.
Now, your lords, may kindly come to internal page 39, that black letters, my lords, 39 on the right hand side. Black numbers, man. Lordship, 6.
39, right?
Yes, my lords. Lords, may kindly see 39, that paragraph, my lords. Just above that, mode of selection. That is 38, my lords. May I read 38, my lords?
Yes.
Mode of selection.
Just a minute.
I'm sorry.
My brother is. But while we are getting at the page, my brother is getting at the page. Why did the Kerala High Court say in their affidavit that marks could vary on a day-to-day basis?
No basis.
No, because what I understood, because I was also there in Kerala, so by virtue of my experience, I know that there's only one interview board. Because sometimes there could be a very large number of candidates, so you may have multiple interviewing boards. So there could be, difference in marking.
True, my lords.
Perhaps they were referring to the refreshment that is served to the interviewing members. Because sometimes very often you say, oh, what a wonderful
My lords, there are
set of
interesting
refreshments.
studies on bias, my lords. Even bias tests on judges also, my lords, in the US conducted. And many people, many tests, most of the judges failed, my lords, in bias tests, my lords. Implicit bias, in fact.
Yeah, we are now ready,
Please,
yes.
That's what makes us human. Many a times. Yes, Dinesh?
Please, my lords. 38, my lords, mode of selection. Selection shall be on the basis of a competitive examination consisting of a written examination and viva voce. The competitive examination will be common for the candidates who apply in response to the notification. There are different notifications, my lord, for the reserved candidates also. Come to the last two paragraphs, my lords, may come to. The total mark for written examination is 300, and it shall consist of 2 papers, each carrying a maximum of 150 marks based on the syllabus given below. The prescribed duration of each paper will be 3 hours. The general candidates and candidates belong to other backward classes who secure 50% and SC/ST candidates who secure 40% aggregate minimum for both papers together shall be declared as qualified for viva voce. Maximum marks for viva voce shall be 50. The merit lists of successful candidates will be prepared on the basis of the total marks obtained in the written examination and viva voce. If the number of applicants is disproportionately large vis-a-vis the number of posts to be filled up, the High Court reserves the right to shortlist the candidates by their length of practice at the bar, and such shortlisted candidates alone will be called for the written examination. However, such shortlisting will not be applicable to the candidates belonging to the scheduled caste and scheduled tribes. The schedule of written examination will be announced later.
So even in the notification of 30th September 2015, they say aggregate marks.
Aggregate marks.
And the viva.
True, my lords.
And in the viva, you must get, the total are 50 marks for the viva. So 300 here and 50 for the viva.
True, my lords. Which may kindly see the counter of the response of the High Court will be here.
Left in the rules for the High Court to do.
September 2015 also says aggregate marks. Now, when did this requirement of a minimum cutoff come in Kerala? For this election?
notification.
For this,
Yes, my lords.
when did that come in? Show us that
My lords, this requirement, Your Lordship, may kindly see the decision of administrative committee.
page. Which
86.
document?
The same document, my lords. Page, that black numbers, my lords, 86.
Document number?
I'm sorry, my lords, counter affidavit of the High Court.
That's document 15.
Document number 15, my lords.
You got the counter affidavit, brother, you got it?
Yes, my lords.
Saying is, in the
No,
same
this is
compilation,
after-
86, it's there.
Page 86, my lords.
67
Of this compilation.
67.
The basis of the decision.
Your
Page
quote-
86,
quoted.
that is page 920.
In here,
Some variation, 912.
67, and you can go to 86, page 86.
Pankaj, we go to page 86. Huh?
Starts at 67.
Almost 2 years after that, huh?
2 years.
Selection process took
After
2 years.
87, uska 86 jana.
86.
And all selections in Kerala, my lords, were under challenge. And it's been under. Let me kindly see page 86, my lords, how the decision was taken for the first matter. May I read the decision of administrative committee, my lords? The
Para
administrative,
22. Para 22.
para 22. The administrative committee, which met on 27/2/2017, resolved as follows. The administrative committee considered the marks secured by the candidates in Viva Voce examination. Though in the scheme approved by the full court on 13/12/2012, it is stipulated that there shall be no cutoff marks for the Viva Voce. It is not an empty formality. The Viva Voce is expected to be conducted in a thorough scientific manner. Each candidate has to be interviewed for 25 to 30 minutes. 6 different heads under which the marks are to be awarded, and maximum marks that can be awarded under these heads are also stipulated. So it is clear that certain minimum standards are expected from the candidates without which they cannot be found suitable for the post. The administrative committee, meticulously examined the marks awarded to each candidate in Viva Voce by the members of the selection committee under the above 6 different heads.
After such, I'll just show you the heads, my lords. After such examination, the committee is satisfied that prime consideration of the selection committee which awarding the marks in Viva Voce was the suitability of the candidates to man the notified post. It is the ultimate object of the Viva Voce to weed out incompetent and unsuitable persons who may skew into the survey by marking up answers in the written examination. The catena of decisions of the apex court also lays down the above principle. So the committee is of the firm view that stipulation of 50% and 40% marks, respectively for general and SC/ST candidates in clause 5 of the notification, in the present selection and similar clauses in the other notifications for which common examination was conducted, is essentially applicable to the Viva Voce examination also. Only such candidates who satisfy such above parameters alone should be qualified to included in the select list. On the anxious consideration of the scheme, the committee finds that above view cannot be considered as a deviation from the approved scheme, since it was never the intention of the full court to select persons who do not attain the minimum required benchmarks for such irresponsible post. The split up of marks under the 6 different categories will indicate that 30 out of the total 50 marks is for the first 2 categories, which are of paramount importance of judicial officer in the cadre of district judge. The candidates who had obtained less than 50% marks in the Viva Voce had fared very badly in the above 2 categories, and whatever little marks they had obtained are mainly under the remaining 4 less important heads. That's not, I'll also show you the heads, my lords. And therefore, the committee is of the firm view that they are not suitable to man the post to which the recruitment is carried out. Recruiting such persons will be disservice to the public at large, which was not the intention of the full court. So the final merit and select lists are to be prepared in such a manner that only general candidates and candidates belong to other backward community who are obtained 50% marks and above, and SC/ST candidates who have secured 40% marks above in the Viva Voce are selected. Now, Your Lordship, may kindly see.
Now, Mr. Dinesh.
Yes, my lords.
1 point in your favor and 1 point against you. I'll put you both. Point in your favor is that the committee does not refer to Rule 2C at all, right? It seems to have missed that Rule C had provided for aggregate marks in both. That's in your favor. 1 point against you. If you are right, then there could not have been the fixation of minimum marks in the written also.
Written action, written marks, my lord.
See, the fixation of the minimum marks in the written exam didn't come under Rule 2C. It came under the notification of 30th September 2015.
Please, I have an answer to this, my lords.
Now, therefore, otherwise, technically, if you are right, you can't fix even the High Court could not have fixed a minimum mark even for the written exam. Because the rule was silent. Rule said just aggregate both and draw up a merit list.
Yes, my lords.
Yeah, the best of the lot would have been selected.
My respectful submission is this, my lords. There are Shetty Commission considered this issue and suggested that
We're not going to Shetty right now. We are on this point here. We are now whether it's ultra vires.
Yes. So far as merit is concerned, my lords.
So once we accept that the fixation of a minimum mark for the written in the notification of the High Court, which is an administrative notification, is valid, how can it be wrong? Then how can it be wrong for the Viva?
But Your Honor, kindly see how the High Court understood this, page 91. Then I'll answer this, my lords. Kindly see page 91.
Now there also there may be an answer.
Yes, my lords.
Which is that the fixation of the minimum marks for the written, which took place on 30th September 2015, was before the commencement of the selection process. Was it before the advertisement? When was the advertisement issued?
2015.
Advertisement was issued when?
Notification, my lords. 2015.
13 and 15.
2015, my lords.
30th September 2015 or that same advertisement, is it?
Yes, my lords. 30th September 2015.
Oh. So simultaneously they said we'll have to have minimum marks in the written exam.
Yes. Thereafter, this administrative committee decision was much later.
It was much later.
After the Viva was said.
They participated.
And also that's not
They participated.
Respect to the written examination part of it, we are prescribing the minimum.
Notification, my lords.
That written, that minimum marks for the written.
Yes, my lord. I'm just getting it.
Marks for the interview for the Viva number.
D6, my lords. D6, document number 6.
By the time the administrative committee takes the decision on 27 February 2017, the Viva is already complete, right?
Pretty complete. Viva was in January.
That's the way it's.
Viva was in January.
Egregious because it's.
16 to 24.
That's creating. It's even egregious.
The notification was issued, when the written was held, when the Viva was held.
Before that, Your Honor, kindly see page 91 for a moment.
अभी इतना ही है.
Please, my lord.
Were you in the selection committee at that time or no?
Absolutely. There's a lot of meaning there, man. Very lot of words. Rashmi, kindly see page 91.
Mr. Chidambaresh, what happens is, when the High Court, we've all been, except Brother Narasimha, we've been High Court judges. When you sit in the selection committee, you know, you're looking at the best interest of the institution. The motive is very, very laudable. Question is whether it is lawful. Sometimes what happens is, you know, the High Court judges, you really feel that, look, this is the crop which we are taking into the judiciary, you know, that's what weighs with the...
The cream is to be selected, no doubt, but not after the event. They had the tabulated marks before them. They wanted to exclude one, include another, see the favored candidates. They got low marks in the written examination, jacked up by Viva OC. I'm not attributing any malafide. See the language used by the full court.
We are going for interview now. This is the method.
Can you bring to your lordship's notice the scheme of the examination, my lord, which is very relevant. The scheme of the examination.
Kindly allow me to show 2 pages more, my lord. Kindly allow me to show only 2 pages.
Two more pages, all right.
Question, can you see page 84?
Page 80?
84, same, my lords, the para number 18. Just point out the breaking of my lords, how it happened.
Okay. Same.
Yes, my lord. Page 84, my lords. Knowledge and comprehension, this is part of the counter activity. 10. Skills for judging, 20. High Court says these are the 2 important aspects.
These are the 2 important.
Other lesser important aspects. Ethics and attitude, general knowledge, communication abilities, and character. In fact, my lords, the interview should have been for these 4 elements, not the first 2. First 2 covers the written examination, covered by written examination.
No, it's not like that. But even in the interviews, we have all attended interviews. You actually have questions on a lot of substantive issues. I can tell you that as judges of the High Court, when we sat on these interview panels, Mr. Chidambaresh will also bear us out. At least I used to prepare a question bank of 180, 200 questions, because you would be sitting for 5 days, 6 days, 7 days, after work, sometimes during work days also, but usually after court hours. So the questions which you pose are also on substance, because if this person just mugging up, as a committee says, is he just mugging up the questions, the answers?
With great respect, my lords.
Or sometimes you throw a practical question on, say, res judicata. Not what do you mean by res judicata, but will res judicata apply in this factual situation?
My respectful submission, my lords, so far as this merits of the person is concerned. Suppose a question is put to a question to a person about the constitutional morality. Then some people may say, for example, of this honorable.
Questions by and large are not subjective questions. The questions which are put, say, even at the direct recruitment of district judges, they are all on the nitty-gritties of the craft.
I'll just
CRPC.
Come to page 90.
You asked Mr. Chima. Mr. Chima is also sitting there. He rose from the district judiciary, became Registrar General, Secretary General here, and then a High Court judge. NCLT. So these people have seen the district judiciary over a long period, much longer than us also.
But you must kindly see page 27, para 27, page 91. Marks awarded to a candidate in Viva Voce depends on her performance on a given day. So a candidate who secured higher marks in the previous election need not be.
87.
27.
Yes, 90. Scroll down. Page 91.
Yeah.
Lacking, my lords. Thank you.
That's okay. Affidavit is saying. The affidavit,
it's the affidavit, my lord, the High Court, man. Marks awarded to a candidate. Viva was a depends on.
Oh, that's okay. There's neither here nor there.
Not a.
Tej Prakash is not applicable. How the Ved Prakash Marwa, because Tej Prakash is a case, I just orally submit, my lords, Tej Prakash what it is, how the Tej Prakash came into. Tej Prakash was an issue of selection of English to Hindi translator and Hindi to English translator. Then there was no cut-off marks. After the interview, the Chief Justice suggested, for the High Court only, Chief Justice suggested that there should be 70, those people who have scored 75, the best, should be selected. And those people who are left out, there were 13 vacancies, and 3 were selected. So those people who were unselected, they filed a writ petition saying that initially, this 70, it was from 55 to 75, that 55 is not available, but because this is after the game is split. Then, the Honorable Court referred to Manjushri. And before that, this Honorable Court also held that 309 rules can be retrospective as well as prospective. Thereafter, this Honorable Court proceeded on the basis that Ved Prakash Marwa, that is of Subhash Chandra Marwa, of 1974 judgment, that was not
referred to in Manjushri.
In Manjushri. But Ved Prakash Subhash Chandra Marwa is a case where the marks were raised from 45 to 55.
Oh, I see.
So there is no
Mr.
vested right
Mr.
of.
Dinesh, what we'll do is, now you just give us the 3 or 4 relevant dates in this 2017 selection batch of cases.
Yes, madam.
Since you are ready to the hilt, we'd like to hear you briefly on these judgments also, because we may or may not have to address that in your issue,
Please, madam.
but we'll have some other matters where we may have to go to the constitutional issue also before the CB.
Please, madam.
So we'll hear you on that also, because you are ready with your fact. But just give us the relevant dates in this 2017 selection. The dates are common in all the matters, right? In
Yes,
case-
yes, yes.
Just give us the dates, that's all.
Just give us
I briefly state the
Will you return findings? Can, sorry.
Just give us the dates.
Just give us the dates, so that 17th selection.
The Kerala State Higher Judicial Service Rules 1961 came into force on 11/7/1961. The scheme of the examination is notified on 13/12/2012. The relevant parts of which have not been read over to your lordships till date, which is an eye-opener. I have got 4 points. I have got, I will come to that after the dates of.
You just start, give us the dates.
Yes. Then this notification comes on 30/9/2015.
Asking the scheme of examination is a part of the rule.
The scheme of examination is an administrative notification or it's a part of the rule?
It's an administrative, full court.
It's a
based
full
on
court.
the
It's a full court resolution, I think.
Minutes.
We'll just go to that. That is, we have not seen that yet.
Exactly.
Now, 30th September 2015 is the High Court notification.
Notification. The written test was conducted on 12/3/2016 and 13/3/2016. The notification regarding candidates qualified in the written test came out on 17/12/2016. The Viva OC was conducted from 16/1/2016.
17.
17.
17 to 24/1/2017.
17. 16 and 17.
January, May 1. January 2007.
17 to
24/1/20.
The minutes of the administrative committee is dated 27/2/2017. Which was approved by the full court on 6/3/2017. The final list came on 6/3/2017 on the same day. So I have got 4 points. I will not take more than 10 minutes.
Just 1 second. Should we have finished with Dinesh now? Should we have finished? Appointment issued?
I have been working issues
because there are no interim order.
from
So those will
2017.
continue.
So pretty much, I think they must have been appointed by the governor after the consultation with the governor consults the High Court.
2017, as per the final list, those were appointed and they are continuing in service.
1 year service in the 1 year training in the Judicial Academy in first year. Then they are posted.
You can't disturb posting.
So now you are, and your clients are out all these years.
Out all these years.
Now those people are already in since 2017.
I scored high in the written test.
Now, Mr. Chidambaresh, the only problem,
6 years.
6 years, these chaps have been working now in the district judges, as in the judiciary, right? These are recruitment to civil judge, junior division.
Milord, my
District judge.
Milord, my anxiety is only
This
this.
is a lateral entry to the district judges.
I know it will be difficult to displace them now. I know, but the problem is this. One among the petitioners is doing exceptionally well at the bar. Lord, her chances of being elevated to the bench will be affected because the allegation is you did not pass the district judge selection.
Prima facie, what is, of course, we'll hear the High Court lawyer. Who's appearing for the Kerala High Court? Jose, no?
Naidu, who said he wants to.
Sheshadri is appearing. Oh, yes. All right, no problem.
You can ask.
Now, Mr. Chidambaresh, assuming that you are right, this issue of change of the rules midway, strictly speaking, is a subsidiary issue. Yes, they did change the rules midway because it was after the Viva Voce was conducted that they introduced this minimum cutoff for the Viva as in terms similar as the written exam. But more important in this case is the fact that the minimum cutoff which they imposed for the Viva was directly contrary to the rule 2C3.
Scheme of examination also stipulates that.
Now, Mr. Chidambaresh, having said that, we just look at the scheme of examination in a minute. So really speaking, the reference may not arise in this matter. Two, if you are right, subject to hearing Sheshadri, if you are right, the decision of the High Court to introduce a minimum cutoff was contrary to Rule 2C3. But third, coming to the grant of relief, at the end of 6 years now, when these people are working, we may not be inclined to disturb those who are already working. What we could do is this. We will say that many of your clients would have now joined the bar. Probably all 4 of them have joined the bar. If they are good, they may even aspire to becoming High Court judges in future. We will clarify that our decision not to grant you relief has no bearing on your intrinsic merits. And therefore, the fact that you did not ultimately qualify in this examination will not affect your future prospects in any other selection.
Exactly. This is my apprehension also.
For all we know, any of you may become High Court judges tomorrow.
Hopefully.
Yes, we've had High Court district judges who resigned, joined the bar, and then became High Court judges.
Yes.
Okay. How many in this batch of 4 matters? No, there are only how many petitioners are there?
10.
They are here before us. Everybody served.
My lords, in fact, in 215, although it appears for the Gujarat High Court.
One second. But the fact that our 9, 11 and 12 would have ranked below you in the aggregate marks, that's what you're saying, much below. But the fact still remains that now they've been working as district judges for the last 7 years. Many of them would be now virtually coming on the threshold of becoming High Court judges,
Whereas you would have joined the bar or seen something else, because 6 years wouldn't have gone by without.
All right, look at it from your point of view. Suppose we appoint you as district judges today, or we say that you should be appointed. We can't give you seniority of 2017. Your seniority will come today. But I know they are okay because today this is such a valuable employment under the state. But the point is that, now to displace people who are working, after all, they've worked as district judges for.
There's another issue. There is a human problem involved, my lords. 6 years they are expecting, and the practice also, my lords, side by side.
Dinesh, you're absolutely right. No doubt about it. We are completely with you on that. But, now we have to look at both sides, You have on the other hand, people who are working as district judges for 6 years now to tell them you go home. And after working you tell me to join the bar today, I don't know what will happen to me, because if I don't think I can answer questions of judges as Brother Narasimha was answering until recently.
Narasimha is the only exception.
How will these people even go back to the bar after having been judges for 7 years? It's very difficult to go back to the bar and start a new career,
If it were a selection which is arising immediately thereafter, perhaps we would have asked the High Court to give them some kind of a concession or relaxation and take them in. But then this period of 6 years is something we can't tell the High Court to, in the next selection, give a priority or some kind of.
6 years is too long.
Oh, but then after 16 years.
Yeah, that would be an unfair thing to accommodate them now. You lose seniority in so many things. In service. You see, I was just telling Honorable Chief Justice, for all you know, this decision of the administrative committee might facilitate those who are in practice to come into the bench of the High Court faster than these people who have been selected as district judge. Possible. No. One is just saying, to upset those who are already working.
Can't upset. Mr. Nataraj, you are appearing, you are the one person who is disconnected from the matter in the sense that you are appearing as law officer.
Yes.
What is to be done? You've been hearing the facts.
Some of the persons, if still they are interested, without disturbing them, they can be accommodated at least in the coming this one. Because already they have.
Also, how do we do that, Mr.
And we have already held that it can't be done because
Because
there are
some
future
selection
prospects of
people,
the younger generation which is now ready.
3 vacancies will be taken away from a future selection, for which there would be people who are willing to apply today.
Unduly,
They were not qualified.
they are denied. So one thing.
My Lordship, may only say on behalf of petition number 4, my Lordship, in this particular same set of Kerala matters, petition number 4, my Lordship, she is not only a widow. The challenge is that, my Lordship, she belongs to the OBC PR community. Now, what has happened, my Lordship, the process is now brought to the fore. A new group of people out of which there's not a single person in the SC/ST community, from the OBC community, or from the communal reservation as per the number of Muslims as well. Now, what has happened, my Lordship, is there's an entire under-inclusion which is coming through with this. And here
We leave it to the High Court. Leave it to the High Court and then do it, and you can't get
all these people may have had an opportunity to Viva. My Lordship is right. The aggregate question of whether the marks been taken together to use for the Viva and the written, my Lordship, yes, there is an aggregation there. But the challenge here is, my Lordship, what has now happened in the process, the consequence which has now come in, my Lordship, is that some of the more worthier candidates today stand eliminated entirely. And
You are eliminated.
to the extent, my Lordship, today what is happening is, my Lordship is right, they're coming to the bar. Now, what happened is, my Lordship, last occasion, when the matter before my Lordship, before Justice Banerjee, when the matter should have been resolved. What has happened, my Lordship, the matter has been.
Right, it's been pending for, had we taken up this matter when the reference was made, we would have said, all right, they have no equities, they were just come in 1 year ago.
My Lordship,
See the judicial process, yeah.
my Lordship is rightly mindful of the other persons who've gone in on the bench. But my Lordship, consideration of these candidates.
2018, 18 maybe they could have allowed the petition, you know.
That time it would have been.
If the petition was allowed in 2018, it may have been much more equitable because, you know, these people had just joined in 2017. I mean, there was no equity in their favor. But now by the pendency of this reference for 5 years, Mr. Sheshadri, is he online? Shraddha, who are you appearing for?
My lords, I'm appearing in the petition for the Gujarat High Court, and the scenario in our case is, my lords, that there were 219 posts that were advertised.
A little later. We'll deal with this. We are not dealing with this on issues.
My lords, the only reason I wanted to state is because in our case, this was 2022, and there are in fact 160 posts that are still lying vacant because only 55 candidates out of 219 posts have been selected. And in fact, my lords, the total marks secured by my clients is far higher than the marks secured by the persons who have been selected. For example, my lords, petitioner number 2 in my case, in the written test alone, secured 142 marks, which is what rank 23 has secured.
You are in the same as Mr. Chidambaresh, Mr. P.V. Dinesh, but perhaps you are saying your marks are even better than...
Even higher, my lords. Even in rank, if the cumulative score would have been taken, I would have been in the merit list of top 10 candidates.
2022. You are 2022.
Yes, my lords.
So it's just one year back.
Yes, my lords. And in fact, there are only 55.
We will deal with your case separately. We'll complete this. Now we'll hear Mr. Naidu. I think Mr. Naidu is online.
Is he online? Mr. Jose, Ramesh, is he there? Okay, can you tell us?
Dama Sheshadri Naidu.
You can दिखाया क्या? Dama Sheshadri नहीं.
Send message.
We'll ask Naidu.
So far as accommodating is concerned, considering the facts and circumstances, take a decision on how to accommodate them sympathetically.
Just check whether yes, anybody is interested. Was it a check करने को बोल दो ना Naidu को phone करके. If anybody has Mr. Naidu's phone, just give him a call and say that he can join. We are waiting for him. Huh? All right. चलो खत्म कर देंगे. अभी dictate कर ही देंगे. We are not interfering. We have to be.
Whatever future
exactly.
Dates,
trying to join through court. Mr. Naidu is trying to join through. It's connected through court.
Reference order of Bhanumati. In Jaga, up to 2000. Bhanumati would have referred it in 2018. No?
Trying to join.
So you see, so I don't have to go. Which would. And Joseph and Bhanumati. No? Judgment reserved.
Yes, yes, yes.
2nd November, 14 November. Yes, I got it.
In the meantime, can I point out two other provisions in the scheme?
You wanted to show us the scheme, right?
Yes.
Yeah, we'll just see the scheme. Huh?
In the
What page is the
item
scheme?
is 501.7.
No, the scheme will be there in Dinesh's compilation also.
In, not the, in 501.7 paper book,
Yes.
it starts at page 26. 25. PDF page number 33.
501.7. 501 point. Yes. 62. 62.
Scheme of examination as amended by the full court minutes dated 13/12/2012. Cut-off mark. The candidate need not secure any separate minimum marks for each paper. The general candidates who secure 50% and SC/ST candidates who secure 40% aggregate minimum for both the papers shall be declared as qualified for the Viva OC examination. Then, further down below, written examination. The Kerala Higher Judicial Service examination will have a written examination for two papers carrying 150 marks each and a Viva OC carrying 50 marks. Then,
yes. My lords, can I be heard?
Yes, Mr. Naidu, just 1 minute. We'll come to you in a moment.
Further down below, with regard to Viva
My
OC.
lords,
Just 1 second. 1 second. Yes. Where is it at? Where is the reference to Viva? Yes, at page 28 bottom. That is page 65 bottom.
The Viva OC test should be in a thorough and scientific manner, and it should be taken anything between 25 and 30 minutes for each candidate. There shall be no cut-off marks for the Viva OC. Explicit in black and white. There shall be no cut-off marks for the Viva OC, which was not pointed out before your lordships earlier. Viva OC shall be conducted by a board of honorable judge constituted for that purpose. The merit list will be prepared on the basis of marks obtained both in the written examination and Viva OC. Then, your lordship will get the notification.
3915.
The notification starts at?
Next page, 31.
Yes. Mode of selection. At page 32 deals with the mode of selection. Then at page 33, if the number of applicants the merit list, page 33 begins this like this. The merit list of successful candidates will be prepared on the basis of total marks obtained in the written examination and Viva OC.
Where is that?
33 at the top.
If the number of applicants.
If the number of applicants is disproportionately large vis-a-vis the number of posts to be filled up, the High Court reserves the right to shortlist the candidates by their length of practice at the bar. And such shortlisted candidates alone will be called for the written examination. The power to shortlist is there, but only on one contingency, only on one criteria, depending on their length of service, nothing else, not on the basis of marks in the Viva OC.
This has not been varied.
And this has not been varied.
Nor the scheme.
Nor the scheme.
Perhaps it is actually variation.
It is a variation. Because that was approved by the full.
This is also wrong because application use.
Kindly see the language of the minutes of the full court, or minutes of the administrative committee. That is at page 46. 46. Paragraph 2. The administrative committee meticulously examined the marks awarded to each candidate in the Viva OC by the members of the selection committee under the above 6 different heads. After such examination, the committee is satisfied that the prime consideration of the selection committee while awarding marks in the Viva OC was the suitability of candidates to man the notified post. It is the ultimate object of a Viva OC to weed out incompetent and unsuitable persons who may squeeze into the service by mugging up answers in a written examination. This elevation to the bench, squeezing into the service. The Katanoff decisions of the Apex Court also lays down the above salutary principle. So the committee is of the firm view that the stipulation of 50%, 40% marks respectively for the general and SC/ST candidates in clause 5 of the notification in the present selection and similar clauses in the other notification for which the common examination was conducted is essentially applicable to the Viva OC examination also. Then towards the middle of the next paragraph. The split up of marks under the 6 different categories. 6 different categories are knowledge, skills, attitude, ethics, communication, character. The split up of marks under the 6 different categories will indicate that 30 out of the total 50 marks is for the first 2 categories, which are of permanent importance for a judicial officer in the cadre of a district judge. The candidates who had obtained less than 50% marks in the Viva OC had fared very badly in the above 2 categories, and whatever little marks they had obtained are mainly under the remaining 4 less important heads. And therefore, the committee is of the firm view that they are not suitable to man the post to which the recruitment is carried out. Recruiting such persons will be disservice to the public at large, which was not the intention of the full court. The beginning of the minutes also, para 1. The administrative committee, previous page, the administrative committee considered the marks secured by the candidate in the Viva OC examination. Though in the scheme approved by the full court on 13/12/2012, it is stipulated that there shall be no cut-off marks for the Viva OC. It is not an empty formality. Viva OC is expected to be conducted in a thorough and scientific manner. Each candidate has to be interviewed for 25 to 30 minutes, 6 different heads under which the heads marks are to be awarded, and the maximum marks that can be awarded under these heads are also stipulated. So it is clear that certain minimum standards are expected from the candidates, without which they cannot be found suitable for the above post.
Mr. Naidu. Thank you, Mr. Chidambaram.
Yes, my apologies. And it's nothing short of foolhardiness and audacity on my part being absent. I was away Millers because I thought my turn would be later.
You were in enough factor, Mr. Sheshadri.
Yes.
Yes, Millers.
Yes.
Millers. It seems something fell from your lordship. That's what I was told, Millers. I gathered that without any stigmatic remarks, could they be dispensed with? Because Millers, we took a conscious decision in the full court.
Sheshadri, we are inclined to take the view that the High Court decision is completely wrong. For the reason, first and foremost, that Rule 2C3 specifically says that the selection will be made on the basis of the aggregate marks, which are obtained in the written test and the Viva. Now, if that is applied, what you have basically done is that, forget the fact that the decision was taken midway through the selection process. We'll leave that aside for a moment.
Yes.
What you did was you said by the full court decision that the minimum cutoff which has been prescribed for the written exam shall also apply to the Viva. As a result of this, what happens is that those who get selected, actually, as a result of this, those who get eliminated on the ground that they have not got the minimum cutoff in the Viva would have made it if the selection was made on the basis of the aggregate of marks in the written examination and the Viva. In other words, what you have done is plainly contrary to Rule 2C3.
4 factors are clearly against you. First of all, it is contrary to the rule. Number 2, the scheme specifically provided a distinct method which is to be followed, and cutoff mark was not permissible. Number 3, the notification said that if there are overwhelming numbers, then we will go only by the number of years in the bar. Number 4, this decision of the administrative committee is actually after the interviews were over. These are the 4 factors which give a clear answer to the fact that the decision of the High Court is wrong.
Millets, only when we went to the hustings, we realized the practical difficulties and the impossibility of the process. I submit, Millets, it's true that the rule stares at us, but the problem is this, Millets, in the overall interest and efficacy of the adjudication at the lower levels, Millets, at the district level, we had to take this step consciously, all the full court unanimously. But the difficulty, I submit, Millets, the tendency has grown recently that most of the aspirants never attend the course, never practice. They go to coaching institutions, they get trained like automatons, and then they score very high in the written examination. When faced in the Viva interview, Millets, which is a vital part as to their practical knowledge, they have been absolute zero. And it started us.
Ground for you to modify your rule so as to provide for a cutoff specifically in the rule. Nobody's challenging the desirability of having a cutoff of a minimum marks in the Viva Voce. But you must then specify it in your rule, which you have subsequently done in 2017.
But your notification said practice in the bar will be the
And you know your
I reckon, Millets, when it comes to the appointment of the high judiciary in the sense of district judges, it may not be an ordinary post. Millets.
Sheshadi, the scheme specifically says that the shortlisting will be made on the basis of the years of practice in the bar if the number of candidates is unusually large.
Specifically provided that the cutoff marks for interview is not permitted under the scheme. You have said it.
Millets, it's an exceptional decision under exceptional circumstances, only in the interest of efficacy at the district level, because they had all been young.
It's we'll come back and dictate a short order after lunch in this matter. So 4 matters of Kerala will be over. Instead of starting now and come back after, dictate it after lunch.
Great.